Welcome back. Here with us on Mirror Now, and this is Urban Debate. If the apex court of the country has to reiterate again and again that bail is a norm and jail is an exception, it's an indication that it is not being followed. There is a serious problem. Second time in 2 weeks, the Supreme Court has expressed concern over this issue. Yesterday, specifically on the existing mindset of the trial courts in the country, the Supreme Court observed that if there are hundreds of reasons for denying bail, then also hundreds of reasons for granting it. Another strong observation was made that the mindset is to find a way to deny bail, and that has to be changed. There are currently around 3.30 lakh under trial prisoners in Indian jails. That's the last official update that we've got. That was in 2019. Many probably are not getting the bail due to this mindset. In fact, therefore, on Urban Debate this evening, we will try to find out the reasons behind the reluctance in trial courts and what must be done to change the mindset. Remember, the right to seek default bail under Section 167(2) of CRPC is a fundamental right and not merely a statutory right, which flows from Article 21 of the Constitution. And joining me on this debate this evening is retired Justice B.A. Khan, former Chief Justice J&K High Court. We have Justice AK Ganguly, former Judge Supreme Court, KC Kaushik, former ASG. We're also joined by KK Manan, who is a senior advocate. Good evening to all of you gentlemen. Mr. KC Kaushik, I want to begin this discussion with you. Now, very scathing observations have been made by the Supreme Court yet again on the issue of bail, how probably it's being denied by the lower court specifically. I want to understand from you, in your opinion, why is there this reluctance in the lower courts when it comes to granting bail? Mr. Kaushik, can you hear me?
Please tell me. I'm hearing you now.
I'm trying to understand from you, sir, why is there this reluctance when it comes to granting bail in the lower court specifically?
Because I will tell you the reason. As far as the lower judiciary is concerned, they are scared if they are granting the bail, there could be administrative action against them. Because these are the open secrets nowadays. Because the difficulty is, as far as the administrative side is concerned, most of the time, the lower judiciary is scared, they may be held up by one or the other reason. So that is the reason they are reluctant to grant the bails even a reasonable cases. They always try to transfer the cases to the upper court, so they let the upper court decide the issue. In maximum cases, whatever we have found in my experience for last more than 40 years in the practice, nowadays the lower courts are very reluctant to grant the bail. But even in some cases in the High Court also. But the difficulty basically as far as lower judiciary is concerned, they are feeling demoralized to that extent. If they grant the bail in a cases, they may be held up in the administrative side. This is my experience says. Or these are not my experience. These are the experience of different people. Because here, retired Chief Justice is there, retired Supreme Court judges there. They will bear with me. They must have having the same experience when they deal the issue in the administrative side. As far as the judicial side is concerned, the lower judiciary, because they are joining the service as a PCSJ. So initially they are appointed as a judicial magistrate, then CGM, then additional district judge, then district judge. So whenever the matter is coming to the lower judicial officer, they are reluctant to grant the bail even in a given case. But we can hope some. As for when the matters go to the district judge, where there is a borderline cases, normally the district judges are granting the bail. But as far as the High Court and Supreme Court are concerned, they are, of course, they are granting the bail. But this is the observation which has come recently by the Supreme Court, which is a very alarming situation. So the judiciary has found out the way out. Why the lower judiciary is reluctant not to grant the bail? This is my view on the issue.
Okay, okay. So, Justice Khan, to you
Hello.
now. You've heard what the former ASG has to say. So, the perception, Justice Khan, is that probably, as far as trial courts are concerned, there's some kind of fear. In your opinion, sir, what could be the reason?
Ma'am, partly to what Kaushik was saying, we have come across such instances where some of our judicial officers at times felt scared. That's true. Now, let me compose myself. I am fresh from a television show showing that con man Chandrasekhar, I think, persuading the wife of a businessman to part with 215 crores of rupees for grant of a bail, and he is acting through allegedly through the Government of India Home Minister's office or whatever. But that has shaken me. It will take me some time because one of the references made in that audio was that you don't have to worry, everything is in the Supreme Court. Now that has shocked me, and I don't know what to say. Is there a public perception that bail orders are purchased from courts? And can you part with 215 crores of rupees for purchasing a bail order? That is one aspect of it. Now, beyond that, ma'am, on the merit of this subject which you have taken up, I have a different take altogether, because the observations which you are referring to, mindset and all that stuff, that is theoretical. Why it is theoretical? Because judicial functioning is dependent on the outlook and aptitude and attitude of every person who is sitting as a judge. And you have different types of judges. You have liberal judges, you have conservative judges, you have this judge and that judge. And no, all are afflicted, or all have their baggages, all have their predilections, all have their outlooks. So those outlooks reflect in the orders they pass. Number one. Number two, it is not that you can implant a mindset in a judicial officer. That can't happen. I mean, he's a human being. You can't whip him up and tell him that you do this and you do that and then. Number two, judicial functioning is not something static. It is not within a straitjacket formula that 2 + 2 makes 4. And when you have this situation, then therefore you have to grant a bail. When you don't have this situation, that you have to release on bail, so on and so forth. It's an evolving situation, depends on what is before a judge. Now, what is before a judge is something which is not before some other judge. Suppose I am sitting at a higher place as a superior appellate authority. It's not before me, so I will not be able to say why he exercised this judicial discretion, why he did not exercise this judicial. Should he have done it this way or should he have done it that way is unknown in judicial functioning. If a magistrate exercises jurisdiction on sound basis, it is not for the Supreme Court to say, unless the Supreme Court finds the order perverse, to say that he acted wrongly. Now, this is the nature of judicial functioning. Now, third thing which I want to say is, yes, there are problems. Problems are that we don't have the requisite training and outlook to see how to balance between a constitutional right of liberty and the limits of an investigation, which is authorized by the law. So we don't have that outlooks prevailing at the level of the subordinate judiciary. Why we don't have that? Because there is a shortfall or deficiency of training, and there is a faulty recruitment. Now, that faulty recruitment throws up people who have no concept of what a constitutional right of liberty is. Now, if he has no concept of that, then how do you expect him to balance it with the limits of investigation and to see whether the arrest is good or bad? Third thing which I want to point out, that the grant of a refusal of bail is mostly afflicted by prejudices, biases, likes and dislikes. And now I hear this story of this con man. It's extra considerations. This is not something. This is not an exercise of a sound judicial discretion. Now, sound judicial discretion would be what transpires from your record and whether the fellow deserves bail or does not deserve bail, for which there are set norms already pressed by the Honorable Supreme Court. Now, who cares for those norms? Bail has become something with which you can punish. Bail has become something with which you can indulge in a luxury. Bail has become what? Bail is no longer free now. It is granted either in a routine matter, it is either granted for something or not for something. And there, I don't say that this happens in majority of the cases, but this is the situation. What Kaushik was pointing out is also a part of the fact.
Right.
That a subordinate judiciary
those are
officer,
points that you have made. Okay, Justice Khan, those are some important points that you're making. I want to now go across to Justice AK Ganguly as well. Sir, you heard the two sides here. Now, in your opinion, why is it that the top court, the apex court of this country, has to reiterate the same point twice in just 2 weeks? It means something somewhere needs attention. Everybody can't be approaching directly the Supreme Court if bail is required, or maybe the High Court for that matter, because at lower courts they're not able to get it, even if they have a case, a strong case.
Yes, I very much welcome the attitude of the top court, the Supreme Court, in reiterating that in a matter when a person is accused, he is an under trial prisoner, he has the safeguard of liberty around him. He is presumed to be innocent till the contrary is proved. This is the classical law. But in a matter of grant of bail, the judicial discretion is not properly exercised by the lower courts. And Supreme Court had found that in normal cases where bail is a routine thing, where bail is the rule, that has been said by Justice Krishnaya, the bail is the rule and jail is an exception. Where bail is the rule, even in such cases they are not granting bail because they are trying to play safe. The lower judiciary is trying to play safe by not granting bail. They say if we grant bail, we may be chastised. Because this trend, I tell you, started, I can't name the learned judges of the Supreme Court, but somewhere down 1990 or thereabout, the learned judges of the Supreme Court took upon themselves to criticize bail orders granted by the district courts. It's a matter of discretion. In a matter of discretion, I may think one way, the other person may think the other way. Both may be right in their own view. But the Honorable Supreme Court judges, taking advantage of their superior position in the hierarchy, started castigating, passing strong, drastic orders against the order granting bail, which used to ruin the career and the prospect of the judges at the district level. They have become very scary now. That is the reason why the bail jurisdiction is not properly exercised by the lower judiciary. As a result of which, bail applications, because it's a concurrent jurisdiction, the jurisdiction of the lower court and the jurisdiction of the high court is concurrent, it is not revisional. Therefore, as it is not granted by the court below, there is a lot of pressure there on the High Court and then ultimately on the Supreme Court. Normally when we were lawyers, say in the 80s, early 80s, mid 80s, hardly any bail matter used to travel right up to Supreme Court because we knew Supreme Court will not interfere. Whether an order of bail has been granted or whether it has not been granted, this is a matter of pure discretion and interlocutory order. But now you see the Supreme Court is flooded with cases of bail, and I'm very happy to see, because I am a pro-liberty judge, I'm very happy to see that under the leadership of Justice Chandrachud, the present judge, very eminent judge of the Supreme Court. A trend has started whereby the liberty of the individual is asserted, and Justice Chandrachud in several cases have pointed out that liberty of the individual is a non-negotiable virtue, and unless it can be shown that the accused person is going to tamper with witness or is going to influence in any way influence the witness or tamper with evidence or is going to run away, he should be granted bail unless there is a statutory bar. This is being reiterated by Supreme Court time and again, because the Supreme Court wants to reverse its earlier trend. This is a very healthy trend, and I welcome this in the interest of the liberty of the individual, in the interest of protection of his fundamental right under Article 21. I welcome this trend. This is a very healthy trend. And the lower courts must
Justice
take
Ganguly, I will also like to... Yes, Justice Ganguly, I also will like to seek your opinion on the issue of mindset that was raised by the Supreme Court yesterday. But let me just quickly take the opening comments from Mr. KK Manan as well, senior advocate, also with us on the panel this evening. Mr. KK Manan, a lot of time we have seen if somebody is seeking bail, then it is very, very difficult at the trial court level, and mostly it's only at the high court level that, bail is granted. Tell us a little bit about your experience, and what do you say about this reluctance?
First of all, I would like to welcome the judgment of the Apex Court. But at the same time, I can't restrain myself to say that the subordinated judiciary is totally under pressure. They don't grant bail easily. The bail should be granted by a magistrate. Even we can't and we are unable to get from the Sessions Court. And if the bail should be granted by the Sessions Court, then even we are unable to get the bail from the Honorable High Court. Now you see the condition today that Delhi High Court has 6 judges who are sitting on a criminal side. Only they are dealing with the bail matters. You can see how the High Court, especially I'm talking about Delhi High Court, Punjab and Haryana High Court, go in Rajasthan High Court or any Honorable High Court, 5-6 judges are sitting only to deal with the bail matters because the bails are being flooded, not being given by either by the Sessions Court or by the Magisterial Court. You know why? Because I welcome this judgment, but how many days this judgment will be followed by the subordinate court or the Honorable High Courts? I will say they will not. You see, sometimes we argue a fit case for bail, while rejecting the bail, neither the prosecution nor the defense cited the judgments. The magistrate or the Sessions Court cite the judgments which are against the accused not to grant the bail suo motu. It's very, I fail to understand. Sometimes I ask the judges from where and by whom these judgments have been referred. But they have to dismiss the bail application. So they refer and they have taken and noted down the judgments to reject the bail application. They have prepared the register for those and to, this and that. Rightly pointed out by Justice Ganguly, that Justice Krishna Iyer, that was the era, Justice Ganguly ji. That was the era of Justice Krishna Iyer, not in one case, in a number of cases. He delivered the judgments, he delivered the bail orders, a very famous order. It's a very short order, by way of a order, not a judgment, Harsh Sani versus UT Chandigarh. That he said to the extent that if there police wants to make a recovery from this lady, that there is not a bar, even if she is on anticipatory bail, she can be compelled to get it recovered, whatever she is having possession of those articles. But today, merely on the ground, the recovery has to be effected. He is required for a custodial interrogation, anticipatory bail dismissed. Not only that, so for a regular bail application, two types of bail
Those
applications
are
are there.
important examples.
First, anticipatory bail.
Mr. Manan, I'm just interrupting you there. Right. Mr. Manan, I'm just interrupting you there.
Yes.
I'll come to you, sir. I'll come to you and I'll listen to your examples as well. Justice Ganguly has to leave, but I want to just, with his permission, ask one more question, if he can answer that for me. Sir, the Supreme Court mentioned that, the mindset of finding a way of denying bail of the trial court should change, something that Mr. Manan also just now mentioned. So what can be done, sir, in your opinion, to change the mindset? We've understood there is a problem. What can be done? What is your advice for the trial courts?
No question of changing the mindset. They should follow the Supreme Court direction, because that is binding on them under Article 141 of the Constitution. There is no question of a mindset. Under our Constitution, under Article 141, what the principles laid down by Supreme Court is binding on them. They must follow it like a Bible. There is no question of a true opinion on this. Supreme Court is disturbed that its order is not followed. Therefore, Supreme Court is reiterating it. I think before this order, the Supreme Court passed a similar order in October. Supreme Court is reversing its previous trend, where bail order has been commented upon adversely for a very trifling reason. I don't want to name those unlearned Supreme Court judges, but the present Supreme Court trend is very healthy trend. It is in accordance with the constitutional principle and in accordance with classical jurisprudence of criminal law. The principles laid down by Justice Krishna Iyer are valid principles. It is no good saying that those days are gone. Those are still good laws. Nobody can say that Krishna laid down principles which are not legally sound. He was one of the best judges that the Supreme Court has ever produced, and we should all follow his principles. There is no reason to make a departure from that. And the presently Supreme Court is reiterating the very same thing without naming Justice Iyer. I think we should follow that principle. There is no question of a different mindset. You are not doing anything. You are doing your duty, and at the same time, it's a question of liberty of a citizen. I mean, when his innocence is not tarnished, at that stage, you cannot deny him his liberty just on the basis of unfounded allegations. You must judge. Of course, there are cases and cases. I'm not saying you must follow a straight-jacket principle in every case. There are cases. That is why your discretion should be properly exercised. It's a matter of judicial discretion.
Very, very important words there, Justice Ganguly. I appreciate your time. Thank you very much. Yes, sir, absolutely. And Mr. Manan, I believe you have a different point of view.
Unfortunately, yes, of course, my lord, I have every respect for the judiciary. I bow my head before the Honorable Supreme Court, High Court, and even including the subordinate judiciary. But at the same time, with great respect, I say, even from the apex court also consistent law is not being coming and not pouring, because one bench is giving and delivering the judgment on the same set of facts different, and the another judgment, another bench is different, my lord, with great respect to the institution. But at the same time, mindset at the moment in the subordinate judiciary is, I will say, that they usually don't grant bail 99% now. 99%. Few judges are there. I say out of 100, 2 or 3 maximum. Because I start my practice from the trial court till now doing it till Supreme Court, maximum in the High Court. So with great respect, I say the era of Justice Krishna Iyer has gone. Now, Yes, of course, somewhere
Okay.
era
Now,
is coming
Justice Khan,
by way of,
Justice Khan,
I
now
can say,
what
the
is it
way
that needs to be
judgments are
done?
being coming
Because the
from
Supreme Court
Justice
has
Chandrachud.
mentioned that there needs to be a change of mindset.
No, ma'am, to
Yes,
me,
sir.
it's all a hyperbole. This is saying something which is theoretical and which is not percolating down the ranks. Then what do you get out of it? Justice Ganguly was referring to the judgment of Justice Chandrachud's propounding a concept of liberty and all that. Where did that go? It stopped only at one case of that anchor. Was it followed by Bombay? In Bombay courts thereafter, so many Bombay hit cases we had. Now, all I'm saying is that there is no mechanism by which the superior court, say High Court or the Supreme Court, can invigilate the exercise of a sound jurisdiction by the magistrate down below. And there can't be a hard and fast formula that say, no, you have to grant bail in this and you don't have to grant bail this and you don't have to do this, you have to do this. That can't happen in a judicial functioning because a magistrate's judgment is as good as a superior court's judge. So it can't be said that, look here, you did this, you do this, you do that. No. This is not because judicial functioning nature is different. Now, third thing which I want to point out is that this is also a very misused jurisdiction. Bail jurisdiction is also a very misused jurisdiction. As I was pointing out to you, that at the lower level, sometimes there is a routine handling of the bail matters. And you have what? You have preposterous orders. You have orders proceeding on dislikes and that likes. Sometimes I don't want to say those cost biases and all that stuff. But that happens. And what are you getting out of that? We have seen, I remember I was in the Madhya Pradesh High Court, we dismissed some 16 officers for passing reckless orders. For in an NDPS case, you grant a bail overnight. How is that possible? It's not possible. So that's a misuse of the jurisdiction. Now, what I'm saying is the problem is that bail grant or refusal of bail involves an exercise of a judicial discretion. Now, that judicial discretion exercise can't be confined to some uniform jacket. It differs from judge to judge, as Mr. Ganguly was pointing out. So if that be so, then what do you do out of it? Now, these cliches that Justice Krishna Iyer said, jail not a bail, jail not a bail. Now, this we have been using all the time, but it must happen on the ground also. Now, how does it happen on the ground? It will happen on the ground
So what
only
is the
when
solution?
the
What is the solution then, Justice Khan? You know, as we speak, sir, on social media as well, people are reacting. And one person has written, I just want to read out one line. Many innocent and underprivileged people languish in jail because they are not able to get bail.
True. Yeah,
So
true.
this is from a viewer who's watching us
Yeah,
right now and responding on social media. Then what should be done? What should be done, sir?
There is no outlook. There is no a magistrate. For example, even if he grants a bail, he says give a surety of 50,000. Now that fellow has nothing to eat. Where will he get? That is why your jail population is 2/3 of these under trials. Because there is no outlook. There is no exercise, discretion of exercise. In those days of Krishna Iyer days, he had to compare what his position of substance was. Now, what I'm saying is that for God's sake, our judiciary, firstly, you say what should be done. I would have 2-3 offhand solutions. I don't know how much they might be, whatever they may be. One, for example, would be this concept of liberty, which is propounded by one judge of the High Court. Let there be a list of guidelines on this. Now, if there is a list of guidelines, for example, if you have an offense involving a punishment of this much of years, release. If you have an offense, only ensure that you are ensuring the attendance of the witness and you are ensuring that she is cooperating with the investigation. And these bail bonds, because Krishna Iyer was a pro-labor man, so he said, no cash surety should be asked from a poor man. That was an outlook. Now, how do you implant that outlook? When you say change the mindset, change the mindset. How do you change the mindset? Mindset you change by training. Where is the training of the judicial officers on this? Mindset sets you change by recruitment.
So perhaps
Get the recruitment on merit. Mindset
perhaps
you
that's
change
an important point.
just a minute,
Training is
mindset you
something
change.
where it can begin.
Mindset you change by the invigilation of the Supreme Court and the High Courts. Where is the supervision mechanism of the High Courts
Right.
in these matters? Now, if
Two
you
very
do all
important
those
points,
things,
Justice Khan, you've raised: training, supervision by the
Yes.
High Court. I mean, I think those two can really bring about some kind of a change. I'm completely out of time.
Our judicial system.
Yes, yes. You're making very interesting points. I want to give the last word now to Mr. K.C. Kaushik. Then I have to wind up this debate. Yes.
According to me, there seems to be consensus all the panelists here today, because there is a stress among the judicial officers of the lower judiciary. So the high courts, respective high courts, will find out the solution how to release their stress on the issue, so that they can think over that there is an article of 120 in the Constitution of India. As far as the Article 21 is concerned, that is existing right from the beginning, when the Constitution was implemented in India. As far as the Justice Krishna observation is concerned, bail is a rule and jail is an exemption. This quotation was delivered by the Justice Krishna long back. But as far as the implementation is concerned, that is not coming out very frequently. So Justice Chandru has reiterated the same things. According to me, unless and until we are in a position to release the stress of the lower judiciary, so no solution will come out. Let me tell you one thing. As far as the lower judiciary is concerned, even with greater respect to the judges, those are elevated from lower judiciary to the high court judge also. They sometimes lack lacking as far as the constitutional provisions are concerned. So we can try to educate and train them, the lower judiciary, especially as far as the Article 21 is concerned, so that they may feel elevated to themselves. We could, if we are
Right.
doing justice, and we are the custodian of the life and liberty, so things could improve, according to me.
Right. All right, gentlemen,
Hello.
I appreciate all of you for joining us here on this very special debate on Mirror Now. And we can really hope that, as second time in about 2 weeks, the Supreme Court has reiterated this issue, that there is some kind of reluctance in trial courts in granting bail. Hopefully now, with their new direction of a need for change in mindset, things start getting better. Thank you very much, all of you, for joining us. Heading into a short break, but there is a lot more news lined up for you on the other side. Don't go anywhere.